Separation of Powers and the Independent Counsel, Morrison v. Olson Revisited. A program planned and developed by the Historical Society of the District of Columbia Circuit with video produced by the Federal Judicial Center. October 28, 2015. Amanda Frost, Professor, American University, Washington College of Law, sets the stage for a reenactment of the arguments in Morrison v. Olson. The Honorable Lawrence H. Silberman, Senior Judge for the U.S. Court of Appeals for the D.C. Circuit, presides over the reenactment. Theodore B. Olson of Gibson, Dunn, and Crutcher argues for the appellant himself, and Catherine E. Stetson of Hogan Lovells argues for the appellee, the independent counsel. Afterward, the Honorable Patricia M. Wald, former judge, U.S. Court of Appeals for the D.C. Circuit, moderates a panel discussion with the program participants. And now setting the stage, Professor Amanda Frost.
Good afternoon. So my role today is to set the stage for this reenactment of the constitutional challenge to the independent counsel provisions of the Ethics in Government Act of 1978. I'm going to begin today by giving you the context and the background for the Ethics in Government Act and telling you a little bit about how the independent counsel provisions worked in practice. Then I'm going to move on to talking about the very specific dispute that led to this case coming before the D.C. Circuit. And then I'm going to walk you through some of the major constitutional issues that were raised by the parties to this case. And finally, I'm going to close by talking about the case's significance, which I hope will also be a topic of discussion in the panel that is to follow the reenactment. So I do see a few younger faces, folks born in the 80s or after, and a few law students, including someone else. So I'm going to try to pitch my remarks at a level where it will help everyone to follow along, including those who are newer to constitutional law. So the Ethics in Government Act of 1978 was a direct response to the Watergate scandal that led to President Nixon's, the impeachment proceedings against him, and eventually, of course, his resignation. And in particular, it was a response to what's called the Saturday Night Massacre, where the special prosecutor, Archibald Cox, who was investigating the Watergate break-in, had asked President Nixon to provide the tapes of discussions in the Oval Office. Nixon resisted, and on Saturday, October 20th, 1973, he ordered his Attorney General to fire Archibald Cox, and of course what followed was a series of resignations and ultimately the termination of the Special Prosecutor Archibald Cox. This led, of course, to national outrage, to congressional outrage, and as I said, to Nixon's, of course, resignation following impeachment proceedings. So what it showed the nation was that there was a structural flaw in the way that our government did business. That is, that the prosecution, the task of prosecuting, of enforcing the laws, was given to the executive branch, and this creates a conflict of interest when high-level executive branch employees are the very targets of that investigation. So the Ethics in Government Act of 1978 contains several provisions outlining the role of an independent counsel. And for those of you who want to follow along, you get a great one-page sheet provided to you by the D.C. Circuit Historical Society that can be useful to following the discussion that is to come in the oral argument. And in a nutshell, what this act did was it created a special court of Article III judges who, when asked by the Attorney General, who was required to investigate allegations of wrongdoing by high-level executive branch officials, president, vice president, cabinet members, and other high-ranking officials, if the Attorney General then went to the special court and said, I think there's reason for further investigation, the special court's role was to appoint an independent counsel and establish that person's jurisdiction, the scope of the investigation, and who would be targeted. At that point, the independent counsel was to operate as a prosecutor in the Department of Justice. And in fact, that prosecution was to be paid for out of the government funds in the Department of Justice. And the independent counsel was to have all of those resources, including the ability to hire staff, to convene a grand jury, and of course to eventually prosecute if the evidence led to that conclusion. Now, the independent counsel could be removed, but only under very narrow circumstances. So there was the possibility of impeachment and conviction by Congress, But absent that, the only way to remove the independent counsel was to have the Attorney General decide that there was good cause, physical disability, mental incapacity, or any other condition that substantially impairs the performance of that counsel's duties. And even then, although the Attorney General had that power to, for those narrow reasons, remove an independent counsel, even then the counsel could appeal that decision to the special court, which could reverse the Attorney General's decision to terminate the independent counsel if that special court thought that there wasn't reason in fact or law to do so. So I think that provides a good framework for the discussion to follow about this specific case. So what led to this matter coming before the DC Circuit? Well, it's either depressing or reassuring to see that for the last 30, 40 years of our country, we've been engaging in the same sort of partisan back and forth disputes. This dispute rose from a democratically controlled Congress who had wanted to get access to some EPA documents involving the EPA's enforcement of Superfund laws. At first, there was a claim of executive privilege by the Reagan administration. Eventually, the documents were turned over, but the House Judiciary Committee investigated that. And the House Judiciary Committee, in the course of that investigation, asked Ted Olson, a high-level, high-ranking employee at the time in the Office of Legal Counsel, to come and testify, and he did so. And following that testimony, following the receipt of the documents in the investigation, the House Judiciary Committee issued a report, sent it to the Attorney General, and they asked the Attorney General to further investigate whether there had been either perjury or obstruction of justice by Ted Olson, Carol Dinkins, and Edward Schmaltz. So the Attorney General did this and eventually went to the special court and asked the special court to appoint an independent counsel to investigate, at that point, just Ted Olson. That independent counsel, Alexia Morrison, eventually decided to expand the investigation to include Dinkins and Schmaltz, and that decision was upheld by the special court. There had been some dispute about that. So then she issued subpoenas to Olson, Schmaltz, and Dinkins, and all three respond by seeking to quash the subpoenas, and their argument is that the independent counsel statute is unconstitutional. So they made a number of constitutional arguments, and I'll outline them briefly here, again, to help you follow along with the reenactment that you are soon to hear. So the arguments start, I think the first argument to start with here is the Appointments Clause argument. Again, we have our very useful one-page sheet provided by the DC Circuit Historical Society, which provides the quotes of the relevant constitutional provisions. And the Appointment Clause challenge was an argument that there are two types of officers that can be appointed under the Constitution in two different ways. Principal officers, the argument goes, have to be appointed by the President with the advice and consent of the Senate. Inferior officers need not be appointed by the President with the involvement of the Senate, but rather can be appointed by the President alone or the courts of law or the heads of departments. So the challengers to the independent counsel statute said that an independent counsel is a principal officer, has to be appointed by the President with the advice and consent of Senate. The independent counsel responded, defended her position by saying, no, I am constitutionally an inferior officer, therefore can be appointed by a court of law. And of course, that turns on what's an inferior officer, what's a principal officer. The Constitution does not speak clearly on that question, but it's very likely you'll hear some debate about what powers the independent counsel has and whether they're sufficiently cabined, whether the independent counsel is sufficiently supervised and restricted in their role such that the independent counsel is an inferior officer, or alternatively, that because there's such a broad authority to prosecute with less than complete control and oversight by the executive, that the independent counsel is a principal officer. So that was one major dispute in the case. A related Appointments Clause dispute was even if the independent counsel is indeed an inferior officer, can she be appointed by a court of law? Is that kind of interbranch appointment constitutionally permissible? Maybe courts of law are only supposed to appoint inferior officers within the judicial branch, such as staff attorneys, for example. And so the argument would be the independent counsel is an executive branch officer and so can't be appointed by a court of law. So that question about the interbranch appointment, whether that's permissible, may also be raised today in the reenactment. Moving away from the Appointments Clause, there's also an argument in this case about whether it violates Article 3 of the Constitution, the provision that establishes the federal judiciary. And here the argument is that Federal courts are tasked with deciding cases or controversies. They are not supposed to engage in extrajudicial activities. And here it is, the special court of Article III judges has been assigned the task of appointing an independent counsel, establishing their jurisdiction, and overseeing questions about their removal and termination. So does that violate Article III by giving this court power the Constitution says it shouldn't exercise? And a related point is, does that mean that the courts are jeopardizing individual liberty because they're intimately involved in the operation of the independent counsel statute, and yet they're the very entities that will hear and appeal to the challenge of its constitutionality and will hear legal issues involving the prosecution of the targets of the independent counsel statute. Finally, the last, I think, and probably most important constitutional argument here really is a separation of powers argument, which of course this entire case is a separation of powers case. But this argument turns on the role of the president under Article 2, Section 3 to take care that the laws be faithfully executed. And the argument here is that that's an executive power that can't be taken away from the executive and placed in the hands of another entity. And the argument is that, of course, investigating and prosecuting are inherently executive actions, and yet they've been given to this independent counsel who cannot be terminated by the Attorney General except for under those narrow provisions, the good cause or substantial impairment. And so the argument is if the executive doesn't have the power to fire the independent counsel at will, which of course the executive doesn't, then it is unconstitutional to delegate this purely executive function of executing the law, of investigating and prosecuting under the laws to this independent counsel. And of course, the argument on the other side is this is by necessity. We have the structural flaw. We have a system in which the executive is self-interested when it comes to high-ranking government officials. So we need to give this power to this independent counsel, and there is some executive oversight in that ability of the Attorney General to remove under some narrow circumstances. All right, so I think that's an overview of the issues that you're likely to hear today in our reenactment. But I wanted to say a few words about why we even care anymore. And as many of you know, the independent counsel provision was struck down by the D.C. Circuit 2-1, but then upheld by the Supreme Court in an opinion written by Chief Justice Rehnquist for 7 justices. And of course, then we had, I think it was 11 more years of that law in practice. We saw a number of additional independent counsels, including probably most well-known Ken Starr's investigation of Bill Clinton that ultimately led to impeachment proceedings against President Clinton, and the law was allowed to lapse in 1999. So why are we still talking about it today? Well, first of all, I think that history is very important, and I'm sure will come up in our panel to follow, and how that affects our understanding of the constitutional analysis, if at all. But I would say that this case is important not because of the specific independent counsel provision that was proven in practice not to work very well, I think most would agree, but rather because it's part of a long-standing debate we have about our Constitution and how to approach constitutional problems, particularly in separation of powers cases, but frankly in lots of cases, which is we have this document, hundreds of years old, only a few thousand words, and yet we're expected to have this document govern our nation today, a nation that looks far different than the framers could have envisioned, and we have competing views about what to do about that. And so there's a formalist response that says, let's look at the text, let's look at the framers' intent, let's follow that path because that's the safe and sure and true path, and of course we can amend the Constitution if needed. And then we have a different view, a functionalist view that says, no, when we have a government that has changed so much from what the framers thought, we need to have some play in the joints. We need to look at how the law plays out in practice, and maybe the spirit of the Constitution and its checks and balances is more important to follow by dealing with these structural problems like the self-interested executive unable to prosecute itself. And we should look to that and follow that lead rather than look to the formal parameters of the text or the original intent. So that debate, I don't think we're going to actually resolve today, but I am looking forward to hearing the parties address that both in their arguments and hopefully in the panel after. So like the rest of you, I'm looking forward to watching this reenactment that's to follow. Thanks.
Counsel?
Thank you, Your Honor. May it please the court. I would like, with the court's permission, to reserve 2 minutes of my time for rebuttal. Your Honor, the independent counsel provisions of the Ethics in Government Act strike at the heart of the presidency, usurping in multiple ways his ability to perform his explicitly assigned core responsibility under the Constitution's carefully crafted separation of powers. This is not a small or trivial usurpation. The power to investigate and prosecute is the essence of the President's duty faithfully to execute the laws. This statute presumes that the President cannot be trusted to do so. Its purpose is to take that power from him and vest it someplace else because he cannot be trusted to do what the Constitution assigns him to do. In my limited time, I will focus my remarks on four what I perceive as overarching points. First, no political truth was more important to the framers of the Constitution for the preservation of individual liberty than the separation of governmental power, legislative, executive, and judicial. The accumulation of these powers in the hand of one or even many was considered the very definition of tyranny. Secondly, the framers intended executive power to be exercised by a single person. They considered, debated, and decisively rejected the concept of a plural or multiple executive by a vote of 7-3 on June 4, 1787. This is described in detail in Federalist 70. Third, the central role assigned to the unitary executive was the faithful execution of the laws. The core of the duty to faithfully execute the laws is deciding how the laws shall be enforced, in what manner, against whom, and when. The executive has exclusive authority, the Supreme Court decided in United States versus Nixon, exclusive authority and absolute discretion to decide whether to prosecute a case. And point four, the independent counsel statute usurps the president's executive power in multiple destructive ways. First, there is an impossibly low threshold to require the Attorney General to seek a judge to appoint an independent counsel. He must do so unless he can find there is no reasonable basis to further investigate the allegations.
Counsel, you haven't yet gone to the provisions of the statute which you think contradict the principles that you're setting forth.
The provisions of the statute I perceive as, and I think the court should conceive of and consider in total. It's the appointment pursuant to this trigger that I just described, the fact that the prosecutor must be completely independent from the executive, from the Department of Justice.
That's an overstatement, counsel. My recollection of the statute is that the independent counsel should follow the policies of the Justice Department, at least unless they're impossible.
Unless the independent counsel, in the independent counsel's discretion, determines them not to be possible to follow. That's a very elusive and elastic standard, and it's not reviewable. So, and then the targets of the independent counsel statute are the president himself and the persons closest to the president.
Wait a minute, you said it's not reviewable. The Attorney General could discharge the independent counsel if the independent counsel was proceeding in a fashion which the Attorney General thought was grotesquely inappropriate.
The Attorney General could make that decision if the Attorney General wanted to take the political risks of doing so, and then that decision could be in turn overruled by the court. So and there's no standards in the statute with respect to making that determination, Your Honor.
We should consider the political inhibitions here as part of the constitutional.
The political
question.
Small p implications. This is a political mechanism to take power away from the president because Congress made the assumption that the president, for political reasons, can't be trusted to do what the Constitution vests in him to do, that is to enforce the laws against persons that are a part of his administration. As I said, this is something that not only can be triggered by allegations in a newspaper or something like that, but it can also be triggered by the legislature. The appointment is by the judiciary, which is expected to provide neutrality and independence with respect to someone who is being prosecuted.
Do you think the real problem in this case is that the judiciary appoints a prosecutor?
The real problem in this case is from start to finish, the trigger on the statute, the limitation on the president's discretion, the fact that the Attorney General must seek the appointment of an independent counsel, that the judiciary, the so-called independent judiciary under Article 3, not in making a decision involving a case or controversy, must appoint the independent counsel, supervise the independent counsel, decide the scope of the independent counsel responsibility, and play a hand in the decision as to whether to remove or not. So it's not just the involvement of the judiciary, it's the involvement of the legislature potentially and in triggering this statute. This case arose out of a dispute over the president's prerogative to claim—
Excuse me, counsel, I just want to follow up on one point you made. You're familiar with a statute that authorizes federal judges to appoint U.S. attorneys in the event there's a vacancy. You are familiar with that provision?
I am familiar with that.
Is it your view that that's unconstitutional?
I think that there are issues with respect to that and other circumstances where the judiciary is involved, including the settlement of antitrust cases and class actions and
Counsel,
so on.
I'm not sure you answered my question. Do you think it's unconstitutional or
I
not?
think that it raises constitutional questions, but
we do that all the
not,
time.
Not of the magnitude. I want to focus on the totality. It's not just judicial appointment, but it's the supervision of the scope of the responsibility. It's the supervision of how the person performs his responsibility and whether he can be removed or not. And it's the power to trigger the appointment. It's who can be prosecuted. In those circumstances, the prosecutor is being appointed to do this job articulated by the statute. It isn't, in the words of Robert Jackson's famous speech to the United States attorneys in the early 40s, to identify a person who must be prosecuted or investigated. And Robert Jackson, Attorney General Jackson, made the point in that important speech that to investigate embraces the power to destroy an individual for reputational purposes, and the individual's career can be damaged as a result of that. Those provisions to which you were just referring don't have anything like that in terms of identifying who will be prosecuted. Furthermore, the Assistant Attorney General or the U.S. Attorney has limited to the constraints of the Department of Justice.
So in other words, the appointment power is not that important. You're more concerned about removal, is that correct?
No, I think the appointment power is very, very important because the president, as you know, is given responsibility under the Constitution to take care that the laws are faithfully executed. The president can do that through the power of appointment of the persons who take charge and execute the president's directives.
But in the statute excuse me, Counsel, the statute I'm referring to authorizes federal judges to appoint U.S. attorneys.
Yes, but those attorneys are in turn
subject to removals. That's why I said I thought your basic argument was removal rather than appointment.
It is not just removal. It's the supervision of the Attorney General. The Attorney General can call the United States Attorney and say, do this, do that, follow this procedure, use your resources in a different way, focus on drug relations or organized crime. The policies and the implementation is the responsibility of the Attorney General. I'm very close to the time that I need to reserve for rebuttal. I urge the court to consider it in this context. It isn't just the appointment. It isn't just the supervision. It isn't just the removal. It isn't just the definition of the jurisdiction of the independent counsel. It isn't just that it's an unlimited time and an unlimited budget. It isn't just any of those things. It is all of those things. The purpose and effect of the statute is to take the president's power over his most important subordinates and take that authority and give it to someone else who is independent. That is inconsistent with the assignment of the executive power to a president.
Thank you, Counsel. Counsel for Morrison.
Thank you, Your Honor, and may it please the Court. The first question that you posed to Mr. Olson identified what I think is the fundamental flaw in his argument. For you to be equipped to decide this case, you need something more than rhetoric. You need text and you need precedent. And you did not hear one mention of precedent in Mr. Olson's presentation. But I'll start with the rhetoric, because I agree with Mr. Olson on this fundamental point. The separation of powers.
Well, wait a minute, Counsel. What precedent are you relying on? I haven't, in our research, we didn't find any case squarely at point on appointment authority. Did you have a case that you would like to call to our attention?
We have multiple cases that I would be happy to
One
call
will
to
do.
your attention.
One will do.
If I had one that fit this case on all fours, I'd certainly offer it. But the problem here is what Mr. Olson left you with was a suggestion that essentially the constitutional problem, is greater than the sum of its parts. But we need to look at the parts in order to identify the constitutional problem. It's not enough just to stand up and make a holistic
Your basic argument
argument.
is that your client, in this case, Ms. Morrison, is an inferior officer. That is correct, isn't it? And therefore can be appointed by who?
We do contend that Ms. Morrison is an inferior officer, that she can be appointed by the courts, because that is exactly what the text of the statute says.
As I read your brief, however, you take the position that the only principal officers are ambassadors, public ministers, and Supreme Court justices. That's quite an extraordinary argument. That everybody else, including department heads, are inferior officers, according to your brief.
Judge Silberman, I think I would extend beyond the narrow categories identified in the brief, the suggestion that
You're
there
going to
are...
abandon your brief's position then?
I will abandon that brief's position.
I can
Yes.
understand that.
There are naturally other principal officers that are contemplated by the statute.
In other words, you would include department heads are principal officers.
Yes, but on that point, one of the problems I think with questioning whether Ms. Morrison is or is not an inferior officer is that there is no definition that the framers provided us. So what we're left with is to consult with some of the precedents that I mentioned, Germain and others, to ask what are the component part, what constitutes an inferior officer? It can't be enough for an officer merely to be subordinate. Department heads are subordinate to the president. It can't be enough for an inferior officer merely to be limited in time, because cabinet heads can be limited in time. I do think, though, that it is important to look at the scope and the nature of the independent counsel's charge.
Why isn't counsel correct in arguing that the independent counsel is in some respects more powerful, more important than the Attorney General, him or herself? Because under the statute, the independent counsel can make an independent determination of whether to prosecute someone against the views of the President of the United States. How can you have anybody more powerful than that?
Judge Silberman, that's not exactly accurate. The Attorney General brings the independent counsel into the world. The Attorney General can take her out of it. The fact that the Attorney General, the power resides in the Attorney General to request the appointment of the independent counsel, to declare that there is a sufficient ground for investigation.
Wait a minute. This is a very troubling point, because if the independent counsel decides that she will prosecute X, and the President of the United States says, you know, prosecuting X jeopardizes the national security of the United States. There are matters that we cannot tolerate. And the independent counsel says, well, the statute gives me authority to do so, notwithstanding your views, Mr. President. Are you saying under those circumstances, the Attorney General has an absolute right to remove the independent counsel?
No, but I believe that Your Honor might be overlooking another aspect of the President's power. The President has the pardon power. So even in the circumstance where the President disagrees with the independent counsel's recommendation, even in the circumstance where the Attorney General, left to his own devices, would not pursue the investigation.
Well, suppose the independent counsel wishes to call as a witness someone who the Attorney General and the President of the United States think would jeopardize national security. and the independent counsel states that I absolutely need that witness to make my case, then what? Let's suppose the independent counsel wants to call, for instance, security officials, like Secret Service agents.
Judge Silberman, I think when it comes to the calling of witnesses, there would be two solutions at least. One of them relatively minor and one of them quite radical, but it's available. The minor solution is to simply put in place safeguards against that person's testimony getting out. The major solution, which is available to the president, which is important for this separation powers concept, is the pardon power.
Yeah, but that doesn't help, because the independent counsel is just using, the disagreement is over who's going to testify, not who's going to be a target of the investigation.
Oh, no,
So in other words,
I
the president's
understand.
the only way he can deal with the problem of the independent counsel calling people as witnesses who the president thinks would jeopardize national security is to pardon the target?
That is the nuclear option that I am suggesting, but it is available to the president. If it is an issue of national security, then the pardon power still resides in the president. There is no arrogation of the executive power to any other branch. And I think that's an important element here. When you listen to Mr. Olson's argument and you read his briefs, there is a suggestion that either the legislature or the judiciary or some unknown fourth branch has arrogated unto itself a power that resides with the executive. The Attorney General seeks the appointment of the independent counsel. The Attorney General decides whether the investigation is warranted. The Attorney General can remove the independent counsel.
Wait, stop. On removal, that's a problem. The Attorney General can remove. Then what happens under the statute? The issue goes, if the independent counsel protests, to the very panel that appointed the independent counsel. And as I read the statute, the panel has authority to overrule the Attorney General on any question of law or fact. That's even more than de novo review. That's a double key, isn't it? Basically, isn't the the Attorney General in a position where he or she has to petition the court to allow the removal of the independent counsel?
Your Honor, there's two issues, I think, packed into that. The first is with respect to the overruling on any question of law or fact. The statutory deficiency, I think, at the time of this argument may or may not have been corrected. But to your greater point,
the statute can't be affected. As it turns out, the statute was changed after the oral argument. But that, of course, can't affect the fact that Mr. Olson was held in contempt under a different statute, can it?
Understood, which leads me to the other removal point.
So you give up on that point, don't you?
For purposes of this reenactment, yes. But that leads us, that the question about removal and the question about the constraints on removal lead us to those pesky precedents I mentioned. It already has been made clear from Myers and Humphrey's executor and Weiner and Boucher that there are...
Humphrey's executor's counsel turned on the proposition, which may have been debatable, that the FTC was a quasi-judicial, quasi-legislative body, not a purely executive operation. Everybody concedes in this case that the independent counsel is engaged in purely executive function. Isn't that true?
No, I don't think that's accurate, Judge Silberman.